Are you ready to make the most of your oil and gas mineral rights? Welcome to the Mineral Rights Podcast. Get the knowledge and resources you need to manage your minerals and royalties. Here is your host, Matt Sands.
Hello and welcome to the Mineral Rights Podcast. I'm your host, Matt Sands, and in this interview, I'm joined by my co-host, Justin Williams, and our guest, Justin Rammell with Rammell Law. Justin Rammell is an attorney and native Utah landman with Rammell Law, where he focuses on oil, gas, mining, geothermal, mineral title, and related estate planning matters. He has prepared mineral title opinions across the Rocky Mountain region and advises clients on leases, surface use agreements, title research, and curative issues. His practical experience helps mineral and royalty owners understand how ownership, land status, and development rights intersect. And in this episode, we really dive into mining claims, which is a topic we haven't talked about in the past. So it was super interesting to hear his perspective on that and a whole lot more, including some tips that you may learn for the first time around leasing your mineral rights for oil and gas development and some of the nuances that we should be aware of when it comes to these other minerals that are being developed now. So without further ado, let's dive into our interview with attorney Justin Rammell. Well, hello and welcome to the Mineral Rights Podcast. Thanks, Justin, for joining us today.
Yeah, happy to be here. Appreciate the invitation.
Absolutely. Well, we're super excited to dive into all about mining claims and the nuances of oil and gas law. And so, from a legal standpoint, and before we do that, though, I think it would be helpful to give our listeners a little bit of background. So can you tell us a little bit about where you grew up and how did you get into practicing oil and gas law?
Yeah, that's a great question. I grew up in Teton Valley, Idaho, and kind of northern Utah. We call it the Jello Belt because there's a lot of Latter-day Saints and they like Jello. So I grew up I've stayed in the Jello Belt pretty much. Had my kids up there last weekend visiting family. And we had a lot of farm ground and a lot of water rights issues. And so I was primarily interested in water rights and had some attorneys in the family. And I went out to Nebraska for law school, kind of staying with a farm theme. And when I came out of law school, I went to Grand Junction, Colorado and worked for Williams, Turner and Holmes. And there were 3 or 4 really grumpy old guys in the basement churning oil and gas title, mostly for Chevron for some oil shale. And we did a lot of uranium work as well. There were a lot of junior Canadian companies coming into the Colorado Plateau at the time. And it was a really great experience because these guys wouldn't use landmen. And so we would go do stand-up title opinions. We'd get up early and drive to Vernal and spend the day in Vernal or Duchesne or, Moab, things like that. And it was a great experience. I was on a job panel at the law school, and they were saying, how do you become successful as an attorney? I said, find some grumpy old guys that are about 5 years out from retirement and do whatever they say. And then, you've got your client base right there. So that's how I got started was, these guys were very generous with their time and their expertise. And, as you guys probably know, they don't really teach oil and gas at the law school or mining law. It's kind of a learn on the job from people who know it. And so I was just very fortunate, really, having the opportunity.
That's a funny story and a wonderful upbringing. And mining is its own beast, just like oil and gas law. There's so many things that are interesting about it. It's different in its own ways. And I think listeners will enjoy kind of learning the differences. But what are some of the projects you've worked on that you're most proud of, just to kind of start and give the people an idea of what it is that you actually are working on for folks?
Well, and, this is interesting, too, that sometimes for royalty owners especially, you kind of get caught in this loop of, estate planning, succession planning, how to negotiate a lease. And there are not a lot of new topics. And so I'm kind of hoping that the mining law angle will be a good, just something different for people to think about. And I tell my clients, too, your mineral rights are there for you to profit from. You can't catch a fish on them. You can't camp on them. So we've got to figure out how to maximize the value, and kind of understanding the mining nature of things could help maximize the value. And so some projects that I've worked on, I primarily do oil and gas title opinions is kind of the main gig. But it's funny that I'm a solo attorney. So a lot of the big firms in both Denver and Salt Lake will refer conflict work to me, things that they consider too small, but I consider right in my wheelhouse, and stuff I enjoy doing because it's mostly smaller operators and people who have an idea and they're developing a project. And so I get to go in like a third grader on a field trip and learn and ask questions and see things that are fun. So for example, I've got a client right now. I've got a few clients that are taking old oil and gas wells, call them stripper wells, right? End of the life cycle, but nobody wants to reclaim them. And they're not producing much. And they're coming up whole and they're taking the produced water and they're using that for lithium, to extract lithium, potash, potentially sodium, and other kinds of things. It's been fun to work with all of the different agencies and figure out all the permitting, because in Utah, for example, we don't have brine rules. They're engaged in a rulemaking right now. So a lot of the work we're doing with the Division of Oil, Gas, and Mining, we're seeing impact the rulemaking. So that's fun. I've worked a couple of cobalt projects out in the West Desert that have been spun off to Rio Tinto, and exciting to see that come around. I had a big pozzolan. I had no idea what pozzolan is. Are you guys familiar with pozzolan? It's a cement additive. A guy on a horse saw that he had a pozzolan deposit, and we got that in development, and he made a good profit from the pozzolan. I'm probably saying it wrong too. And I've got a client doing significant geothermal work in Millard and Beaver counties, and it's fun to see how the geothermal rights come into play, because that's just a new emerging area as well. So I've got a lot of things I'm excited about, and we'll probably talk about helium down the road too. There's some interesting helium opportunities out there right now.
Yeah, there's so many aspects to oil and gas, and I'm continually amazed at how I learn something new every day. There's always some new aspect to it, and you alluded to some of that with the lithium, and that's been a big buzzword certainly for the last couple of years. And it'd be great to get your take on that in terms of from an oil and gas perspective. When we were signing an oil and gas lease, I want to talk first about mining claims. So you have, I think, a unique experience in kind of all these different aspects around the extractive industries and the mineral side of things. And I'd really love to learn more about that, because frankly, I know enough about oil and gas to be dangerous. But when it comes to the, staking a claim and some of the hard rock mining and things like that, that's one thing that I've heard about, but really don't know a lot about it. So I'm really interested as well to learn about that. But so let's talk about what exactly is a mining claim, and, where do they exist? Is it on certain types of property? If you see that on a map, is it still valid? What is a mining claim, and what are the nuances around it?
Yeah, and I can soapbox you guys for a long time on this topic, so you may have to interject and say, Justin, let's move on. When we're talking about mining claims, and when you're seeing those at the recorder's office, there's typically a whole section of mining claim books. And if you're going through the records at the Bureau of Land Management with the General Land Office, you're seeing a lot of mining claim activity. And we're typically talking about federal minerals in that case. And it does come into play for, I think, owners, because a lot of landowners may own fee on surface and minerals on part of their ranch, and it may be split estate on other parts where the federal government or maybe the state of Utah owns the minerals on that ground. And they also might see that a mining claim was patented on their property that is owned by someone else, or maybe it's part of their holding, and they're just kind of wondering how it came to be. But the interesting thing about mining law is the general mining law was passed in 1872, and it has really not been changed. I mean, there have been things carved out of it, but it's still in place. And so mining law is so tricky because it's governed by case law and different court decisions. And the courts have done different things, gone different ways. And the mining law also incorporates the mining customs of the local mining districts that we're out and about. So it's a tangled mess. It's not something that AI is good at figuring out yet, which is great for me, so my kids can go to college. So when we're talking about mining claims, there are two types of mining claims that you can put onto a piece of property on federal minerals. And you can still go do this. You can still go stake claims on federal property. It happens all the time. I had someone just stake a claim for a big crystal kind of quartz deposit. It almost looks like Superman's Fortress of Solitude out in the San Rafael Desert. And I haven't been out there yet. I've seen pictures, but I want to kind of crawl in, see if I can get some energy out of that thing. But this is still happening. So the two types of claims are lode and placer. And so if you visit a mining district like South Pass, Wyoming, or Little Cottonwood Canyon, Utah, and you read about these silver mines, what they're doing is they're following a vein of silver in the rock, right? And that's a lode claim. And there's a specific dimension of lode claim. And so if you look at the recorder's office of old mining claim maps, you just see these lode claims one after another. And these people are following the vein. And it gets really tricky. Like, what if I'm following a vein and Matt's following a vein and we hit? Who owns? Well, it's whoever's got the apex, the high point of elevation owns. And if it's me, then now I get all of Matt's and I get all of everybody else's. So lode claims are super interesting. The other type of claim that you can file is a placer claim. And a placer claim is kind of like, think of a wash, the mouth of the canyon where kind of a wash comes out and you're kind of sifting the sand. That's how most of the gold is extracted in Nevada, is it's just they're processing thousands of tons of earth, sifting through it. Those would be placer claims. And, there's been a lot of articles spilled on whether something is a lode or placer claim. And so that's the great debate. So I also kind of want to talk about what you do after you stake the claim historically and what kind of ownership rights you have. Is that a good segue?
Yeah, that'd be great. So I guess when you talk about placer claims, I think the TV show Gold Rush and what they're doing, like in Alaska and parts of Colorado, I know they've filmed stuff there as well. So that's, if I found a gold in a creek or something on BLM or federal land, and I wanted a gold pan or run a placer mining operation there, that's what that would be. That's what I would need, right, for that operation.
That's exactly it. Yeah. And the staking rules are very straightforward. It's a mix of federal and state. You'd essentially stake the claim and put the markers up according to the current state law. You'd file the notice with the BLM and you'd record a copy of that with the county, and you're off to the races. There are still plenty of professional services that will come out and stake claims for you at a pretty reasonable cost and make sure things are done correctly. One thing about mining law is that it's got to be done to the letter. There's no wiggle room in mining law. If it's not perfect, you're out of luck. So Front, for example, out of Elko, does a lot of staking in the state of Utah and Nevada still for that kind of thing. So what do you have once you stake that claim, right? We typically call it an unpatented mining claim. So the term patent means that a patent is like a deed from the United States, right? It's like the first deed that's issued on the land is your patent. And if you've got a mining claim, you would like to move it to patent. And there were all of these steps that you would go through. Or if you're reading Little House on the Prairie, they're talking about getting their homestead patent by fulfilling all of the list of requirements, You can still, in Nevada, get a 640 acre, a full section desert entry land patent or claim, file a claim if you have a well and you kind of fulfill certain requirements. So this is still an ongoing thing. Unpatented mining claims are claims that you've filed, but you haven't moved a patent. And unfortunately, I think it was 1987, as part of the Federal Land Management and Policy Act, FLPMA, Federal Land Management, something like that. FLPMA, Congress removed the funding for the BLM to process claims to patent. And so while technically it's legal to there's a process that you can follow to get patent, the BLM won't process the claim because they don't have funding to do it. So there's this line of patent applications. But before 87, people would regularly get patents. And so that's why you see people with a 20 or a 40 acre lot up in the middle of the Colorado mountains, is because they were able to move that to patent. And once they had patent, they had fee ownership of the surface and minerals. They owned that whole thing completely. So it's not possible to move to patent anymore. So what do you have with an unpatented claim is the question. And you have these rights called pedis possessio, okay, Latin term that means you've got the right to possess that and exclude others to a certain extent, so long as you're working the land. And your goal is to get discovery of a valuable mineral and to file that with the BLM. Once you have that discovery, you've kind of validated your unpatented mining claim, and then you can exclude others. And I would say the big difference with mining claims as opposed to leases and other things is that if you're pulling gold off of federal minerals, you're not paying a royalty. It's free. Because back in 1872, they wanted the West settled, and they wanted people moving out here and getting things done. And so they gave a lot of incentives to the railroads, right, with the checkerboard, and same thing with mining. So still to this day, lithium, gold, silver, copper, cobalt, all of these things are royalty free.
No wonder they don't approve the patents anymore.
Yeah, I mean, you can still pull minerals for free. You just can't own the land outright. But if proven up your discovery of a valuable mineral, that is considered real property interest that you can sell. And there are plenty of mining companies that, will buy unpatented mining claims that have a proven resource on them.
So if you have an unpatented claim, and you mentioned something about discovering valuable minerals. So if you do that, let's say you're in the Colorado mountains, you're in the Utah mountains, and you come across a creek and you have your gold pan and you do a little panning and you say, oh, wow, there's gold here. I want to stake a claim. You mentioned as long as you're working the land, like how frequently do you have to go out there what does working the land mean from a claim standpoint?
That's a great question, because to maintain the claim year after year, the BLM used to give you the option of you could file this affidavit of maintenance, and you could say, I was out there in April digging, and I was out there in May, I put up a fence, and I was out there in June, and you, in lieu of kind of making this a payment, to kind of hold it year after year. The payments are due September 1. Better have that in on September 1. You can pay them online now. Nowadays, you just kind of file that annual assessment, and you don't have to do any kind of record of maintenance. The reason that you're doing the work on the claim is to exclude others, to demonstrate that you have an ongoing interest in the property. There's a District Court of Utah case about this. There's not a lot of case law, and so we kind of have to pick through the case law and do the best that we can. The cases are few and far between, but what you do see is a lot of companies will go out and they'll just plaster 30 miles of placer mining claims to try to exclude other people. But the reality is, if they're not pulling permits, if they're not doing work on each individual claim, probably annually, I think it's a loose definition, then another person could come and start exploring, possibly top stake them is what we call that, and then go to the courthouse for a quiet title. And it's interesting, if you've got competing claims, the BLM does not care. The BLM, you can file anything you want with the BLM. They don't care. They'll stamp it and take your fee and put it in the file, and it can sit there. If you have a conflict in the mining law land, you go to district court in Utah or a district court in Colorado or Wyoming and have that judge who's used to doing divorces and murders and business contracts go, what is happening?
Yeah, that's very interesting. Okay, so that makes sense from an unpatented claim. Now, you mentioned that if you were to patent it, then it becomes you get the fee ownership of surface and minerals. So that converts it. Does that effectively convert it from BLM land to fee?
To private fee ownership. Yeah.
Does that ever expire?
No, it never expires. It's yours forever. And so you can still get patents from the federal government, not on mining claims anymore, not since FLTMA, because they don't have the funding to process it. But you can still do desert entry land patents, especially in Nevada. And there's this really interesting book. I don't know how I actually wrote to his widow, and she has a couple of copies. But Terry Malley worked for the BLM for years and years and years. This is this book is gold to me. I'll never give this book up. And he actually goes through and he lists every act of Congress that permits a patent and talks about the exceptions and things like that, because your rights are really determined on the patent. And people, surface owners or mineral owners, you can go to the general land office is where you would go, Little House on the Prairie days. It's been folded into the BLM, but you can Google general land office and it's on the BLM site, and you can go find the patent to your property and you can read it and it'll tell you exactly what you get and it will cite the statute. And almost all patents to surface, for example, this if you do read title opinions, they reserve ditches and canals and other mining roads that may have been on the property before you acquired the ownership. But you do want to check the rights that you have under your individual patent. For example, a stock raising homestead patent in the state of Wyoming reserves minerals to the US. And that includes sand and gravel. So you got a lot of things to think about, because you could probably ask the question, well, oil and gas, aren't those considered minerals? Why aren't we getting mining claims on that sort of product, right? And the answer is that in 1920, they decided they wanted a royalty from oil and gas. And so they moved it. They created the Mineral Leasing Act. And there have been various acts since then. There's a Materials Act for sand and gravel and stone. There's competitive potash leasing. So they have segregated out various types of minerals for leasing purposes, or the Material Act is they charge a price per ton for different types of granite, different materials like that.
Very interesting. And you'd previously talked about it, and I thought the bucket. So when you're talking about mineral law, you were talking about that there's several different buckets that minerals go into, and it's kind of defined by the laws. And those are locatable, leasable, and sellable. Can you talk a little bit about those, distinct buckets? Being a oil and gas owner, I had not heard it explained that way, though it mirrors, oil and gas law.
Yeah. So locatable minerals would be minerals where you can file a mining claim: gold, silver, lithium, kind of hard rock type, or kind of, valuable minerals, I guess we would say. Fluid minerals have now become leasable. And so you get an oil and gas lease, you get a different types of kind of fluid mineral leases. And then the Materials Act, those are, we said locatable, leasable, and saleable. What was the third? Yeah, it was the third category that I mentioned. Yeah. Those are the materials like sand, gravel, and rock type things. And again, this is just in the federal context. If you are the fee owner of the surface and the minerals, then you own everything. You don't have to talk to the federal government. But I think that these categories and these ideas of minerals are important because, you don't know what a reservation earlier in title says, and maybe nobody's looked at your chain of title, and you really have to kind of understand the concepts to interpret your individual chain of title.
Yeah, and you mentioned something really interesting, and I think this is something that all mineral owners should know how to do, and I describe it in my online course as well, as far as how to go to that BLM, General Land Office, to pull a copy of your patent to see, to your point earlier, did they reserve something? If it was an area that had active coal mining, I've seen where they've reserved coal to the government, or, things like that, that at the time when that land was patented, the government was pretty clear. And, if there wasn't any oil and gas activity, a lot of times you did get the minerals along with the surface. And, obviously it depends on the state and location and kind of the history there. But yeah, that'll tell you a lot. And a lot of times when we talk about oil and gas title, and can you talk a little bit about this, the need to go back and research from patent to present, that concept is talked about a lot.
I've got two very recent examples, two cases I'm actively working on right now. And I'll try to characterize them in a fair, impartial way, even though I'm zealously representing clients on the issue. And my argument is probably a little colored in favor of my client. But, the first is a client's putting a subdivision in southern Utah. And they start going through the title process when they purchase the property, and the title company really doesn't highlight any issues or problems. It's when they go to get funding, the bank gets their own title opinion and goes, we got some mineral issues. We need to get a mineral. We've got some weird language in a deed from the 40s that we need to take a look at. And there was a reservation of valuable stone. What does that mean? What did that mean at the time? What is valuable stone? Does that mean if they are scraping off the topsoil of the subdivision and moving kind of big rocks that are in place, if this stone is valuable, do they need to find the heirs of whoever reserved this stone? And the bank wasn't willing to extend credit on the property until this problem was fixed. And so, complicated issue. And the question is, the bank is asking me, what does valuable stone mean? And I said, it means, I don't know that there's a definition from the Utah Supreme Court about what valuable stone is. So it means whatever that district court judge sitting down in that county thinks it means. So that's going to be a challenge. Another interesting case came up where in an area that historically had not had much oil and gas development, there was a reservation of, and Matt, I think you do talk about this, how we have the concept like your first day in property 101, they say property is a bundle of sticks. And when you own real estate, you really own just all of these different rights, right? So you have the right to exclude people. You have the right to get a mortgage on it. You have the right to sell it. You have the right to pass it down to your heirs. You have a right to build on it. You have this bundle of sticks of rights. And they had reserved the executive right for mineral development and a small royalty. And so they basically said, we reserve the right to make decisions about mineral development on the property, and we also reserve a 1/8 royalty. And so then the client comes and says, what in the world does this mean? And it's a good question. We don't have a lot of case law on these things. What do the judges think this means? Executive rights for developing property, we kind of know what that means. And it's like, you've got to track down the owner of this right because they're the ones that get the decision for the lease. The harder question is, what does that royalty mean? We get 1/8. Is that 1/8 of the royalty that the other mineral, 1/8 of the leasehold royalty, or is it 1/8 of the gross value? what are we talking about here? And so it is important to go through your chain of title and look for this, odd language that could impact a future sale or a future subdivision development or, a future oil and gas project. It's good to be aware of these things.
And it's something that comes up more often than people think. Even with the oil and gas, that's operators spend a lot of their time in division order department trying to rectify things and make it clear and relieve their liability. So I'm sure it is no stranger in any other type of ownership as well.
Yeah, and you just hope that before it goes to a district court and everybody spends $100,000, trying to convince the judge what this royalty clause means, you hope that people will come together into the same room and try to work out a solution that makes sense. These are all very fluid concepts, which I think is what makes this area of the law so much fun.
Yeah, and that's interesting that you mentioned that, because I know in Texas, for example, that concept of fixed versus floating non-participating royalty interest has been litigated, and there's a bit of case law and some recent case law, in fact, that is guiding those decisions when it comes to two parties that come together. It's like, well, okay, what do we how do we handle this? But I hadn't thought about it from other states where maybe that isn't quite as clear, and you have to litigate it to get to a conclusion, or to your point, hopefully just come up with a compromise that works for both parties.
One interesting thing in the state of Utah, for example, is, we've got the Duhigg rule out of Texas that talks about what happens in a warranty deed where maybe there's an overconveyance. And does it come out of the hide of the grantor, or is it proportionately reduced from the language of the deed? And, Texas had the Duhigg rule for a long time, and a lot of other states were pretty happy with the Texas scheme there. Well, the Utah Supreme Court heard a case in the late 70s called Hartman v. Potter on very similar fact pattern, and they did the complete opposite, and they didn't even cite the Duhigg case. And so, you think that some of these oil and gas concepts, these mineral concepts, are kind of fixed based on case law, but, courts do what they want to do. And I think we've seen a trend, especially at the U.S. Supreme Court, and I've certainly heard it and seen it coming out of the Utah Supreme Court, where kind of the political environment is that a lot of these precedential decisions are being reconsidered, in a lot of areas, both in kind of healthcare decisions, constitutional rights. And I've kind of seen it in a mineral case that I had at the Court of Appeals. I kind of saw that Justice Lee, for example, I think he's off the court now, Mike Lee's brother, not a big fan of precedent. He thinks he can kind of redecide things, and it's going to flip-flop people's expectations. And maybe, I guess a positive could be that it'll get people into the room to kind of settle cases instead of kind of trying to read tea leaves of what a justice or a judge might do on a particular issue that you think is well settled.
Let's switch gears a little bit. I'd love to talk about produced water and lithium. You'd mentioned earlier that, and even before we hit record, we were kind of talking about this, and you were looking at some example leases and whether that was reserved by the grantor, what the nuance is. But you just maybe talk a little bit about lithium from the standpoint of a mineral owner, and what are the things that we should be thinking of when it comes to leasing our oil and gas rights, and some of the best practices around protecting your rights to lithium.
Yeah, I mean, I could talk about it in two contexts, actually. There's the context where the minerals are owned by the federal government, maybe on surface land that's fee land, but also just in the context of an oil and gas owner. Maybe I'll talk the oil and gas context first. One thing I did is I just pulled up a couple of leases that I've worked on recently, and I've got examples from Uinta-Wax, Crescent, and EP. I mean, they've been sold, but I guess SM Energy. And there is a mention in the granting clause of all of these leases that is pretty consistent, talking about saving oil, gas, water, brine, and other fluids. So kind of preserving the fluids. But then if you go down to the what's actually being leased, it talks about oil, gas associated hydrocarbons. And so lithium is absolutely not a hydrocarbon. And we should talk about helium too a little bit, but lithium is not included in any of these leases. But for example, there are energy companies that are using produced water from some of their sites as frack water. It's happening all over Utah and Colorado. And the question is, what if there is lithium in there? Because they have the right to use produced water, but what about that lithium? And so I think that's going to be a little bit of a frontier. I don't know if any of these areas have lithium in the oil and gas water zones. Typically, they're found in zones a little higher up. But one thing you can do is you can certainly go get your water tested and see what's included. There have been leases over the years that I've seen that have said something like oil, gas, and other minerals. And so kind of the question there is, well, other minerals, does this include everything? We do have some kind of rules of legal construction, of kind of contract interpretation that says if you're naming specific things and then you say something general, that general word has got to relate back to the specific things. There's a Latin term for it that I'm not going to know off the top of my head. But so I think in those cases, you're not going to see lithium included. I think lithium would have to be called out specifically in the lease. And the royalty scheme for lithium and the way that you'd be paid on lithium is different as well. So you would really want a separate agreement. But one mineral that is commonly found in natural gas is helium. And we do have a helium shortage. And there's a huge demand for helium. They need it to make semiconductors. They need it in the medical. I mean, it's not just kids' balloons, right? But kids' balloons are a concern. If you have kids, you want to make sure there's some lithium around. But it's usually a very, very small percentage. It's usually collected at the gas plant. It's got to be stored in kind of helium. It's the lightest element, I think, not a chemist. And so it can't be stored in typical natural gas infrastructure. It'll find its way out. But, you can get onto the Division of Oil, Gas, and Mining website and you can see the reports, and they keep track of the elements in your gas stream. And you should compare your helium percentage and see if maybe there's some economic potential there. Certainly, there are a lot of companies in the Four Corners area looking at the natural gas down there. It does have enough helium in it to make it worth collecting field wide.
Yeah, when it comes to those, like you said, if you see that you have a percentage of helium, I guess is the expectation then that you should be getting royalties on that helium, and it should be called out.
I think the expectation is that if they're not pulling out, they're wasting it, and so that you're losing value on that. The question is it economic for anyone to chase down? And if it is economic, I think it's worth making a demand and kind of exploring whether there is a way to capture that helium.
Yeah, that makes sense. Back to the lithium question, though, as far as those leases that don't explicitly mention lithium. So if I'm the lessor on those leases, and later down the road, or even during the process of producing the oil and gas, they discover that there's material, commercial quantities of lithium in the produced water. Are they required then, before they can, benefit from that lithium, and that they need to get another lease from you that specifically mentions lithium?
I mean, it's the same. I think it's the same concept as if when they're digging the pad, that they, start finding gold nuggets. I mean, it's not theirs. They didn't contract for it. They didn't lease it. So you would own that lithium, and you would certainly have space there to demand that it not be wasted. So
is it a best practice to exclude lithium then in that case? Like if you have an oil and gas lease, to say, excluding lithium? Or
I don't think any of the leases that I've seen would include it at all, but I have seen it included in geothermal leases. I've absolutely seen it included in geothermal leases. And geothermal development is spreading very, very quickly. Things that were not economic to produce for geothermal purposes are now economic. And there's an article in the New York Times about geothermal, I swear, every week. And so some of these areas do overlap with oil and gas properties. And, typically the geothermal rock is much shallower than the oil and gas zones, but not always. And there will be, if, in a geothermal lease, they will call out specific royalties for the different products that they're going to extract and potentially produce. And the thing with lithium is you're not going to get a 1/6 or a 3/16. It's usually a much lower percentage, it's 2 to 5%, and they calculate it differently and things like that. So you want to treat it as its own separate thing. But I don't think a landowner or a mineral owner signing an oil and gas lease should be too concerned that their oil and gas lease is going to cover lithium. I think that if they look at the records, you can get on the Utah Geologic Surface, for example, see where lithium is. And if you're in one of those zones, it might be a good idea to get the produced water tested and just see what potential might be hiding in there. Certainly, if you're in the Four Corners area of Utah, there's potential for lithium. And, another way to think about it as well is what happens when you've got this existing wellbore on your property, right, that is no longer serviceable for oil and gas. And maybe it's been plugged and abandoned, but, you can go through the core log and you can see that there's a big produced water zone and you're in a lithium area. To typically the wellbore is owned by the surface owner after reclamation. And so you have got some potential there if the cement bond is still good between the well and the rock to go in and maybe solicit some brine lithium development. I mean, it's very popular right now in Arkansas. I mean, it's just absolutely, southern Arkansas is going crazy. I know a ton of landmen that are absolutely devoted to it. Chevron's in it. They've got rulemaking going, and there, a lot of guardrails are being put into place. And so we might see that expand as the demand for lithium rises.
It's a really interesting area. And you mentioned the geothermal leases. I think that's something we've talked about a little bit before, but like you said, it's being talked about a lot in the bigger news. What's unique about geothermal leases? If somebody comes knocking on my door and they want to sign a lease with me, what terms are we looking at? What are you being paid royalties for? How does it work?
That is a really good question. And it honestly just varies state to state. I think the law firm Steptoe & Johnson out of Denver, they did a really interesting presentation that I think is accessible online that talks about how different states treat geothermal rights. Because what is the geothermal right? Is it the surface owner's right because they own the rock and the rock is hot, so the surface owner owns the heat? Is that something that be carved out like a bundle of sticks? Is it the mineral owner because it's making use of pore space where minerals are found? And the federal government takes one position, states take another position, legislatures take another position. Every state has pretty much got a different scheme for how geothermal rights are classified. In Utah, I even went back and read like the legislative history as part of this. Very unclear. I mean, I think if you talk to the state regulators and the way that the statute reads is that it's connected to the water right. And so the groundwater, you can apply to DW, the Division of Water Resources, and get a permit for groundwater. And they would say that the water right is the geothermal right. So if you're a surface mineral owner, then what are the things in Utah? Then what are the things you're thinking about? Well, you're going, well, the water, you're getting a permit for the water, but it is water that's on my property and coming out of my ground. And you are taking advantage of the pore space. And you need a lot of surface development to get this done. In addition, the heat is probably correlated to the surface. And it's not hard to figure it out if the owner is the same. But what happens if it's a split estate and you've got an oil company that maybe owns the mineral right? There's going to be an argument there about who owns what and how. Obviously, the surface owner is going to say this is a water right, it's a surface right. The mineral owner is going to try to find some leverage. The other thing is you might have a conflict between oil and gas development on the property and geothermal, because these wells could be creating pressure differences. There could be surface access issues. There might not be a place for an oil and gas pad because geothermal takes up so much room. So there are a lot of issues to work through based on the title. I think as far as payment goes, you're getting paid off of the electricity that gets sold, and you're typically getting a low digit percentage of the electricity sales is kind of the easiest way to get it done. One side issue there is there are open and closed loop systems too. So some of these geothermal companies are pulling water from here, running it through generators, and then re-injecting it over here and trying to push water through a closed hot water system. And so in that case, there's not much mineral extraction being done. But in other cases in Nevada, they are able to extract lithium and other minerals from the produced water. And so a geothermal lease should really capture all of these ideas about, and the landowner should have a really good idea about what type of system is being utilized and how much ground it's covering and how kind of the pooling and spacing is going to work and those kinds of things.
And I would assume a water tested would be a great thing too. If this situation comes up and you can go get your water tested and know what your percentages are and what you're talking about, you'd be a lot more informed in this situation.
Yeah, I think so. And I just kind of want to highlight this kind of a unique circumstance that may not be so unique for people who have maybe federal ownership on part of their land. But you think about a situation with produced water that maybe contains lithium, maybe contains potash, maybe there's some oil and gas potential on that land. Well, oil and gas, you need a lease under the 1920 Act, the Mineral Leasing Act. Same thing for like sodium and potassium. But even though the lithium is suspended in solution and it's next to sodium, potassium on the periodic table of elements, it's still a locatable mineral. And so if you're taking over an old oil and gas well, you've got to stake placer claims over what you think the spacing unit's going to be, which could overlap onto, for example, in the brine making rules right now before the state of Utah, they're saying 40 acres. So if you've got a well and maybe half of it's federal and half of it's fee and you own all of it, this is something you're going to have to think about. And so the lithium's governed by is not going to be subject to a royalty, and it is a locatable mineral. Is it placer or lode? I think that mining attorneys are confident that it's placer. My opinion is placer. But then if you're extracting potassium, you need a potassium lease. If you want to try to use old oil and gas, you want to keep some tubing down there and try to keep some natural gas for the generator to run, you need the oil and gas lease. So you've got a lot of overlapping concepts for just one well, that's in production.
Yeah, that's fascinating. That is something that there's opportunity there, I think, to streamline that and to maybe clarify some of those things at the federal level, because that seems like it's pretty inefficient when it comes to the permitting and the leasing from that standpoint. But I suppose if you're on the company that's producing the lithium, you're not incentivized to have that change. It's much easier just to stake a claim, I suppose, and
have it royalty free.
And have it royalty free. Exactly. Yeah.
On the other side too, I think a lot of oil company development, mineral development is just built off of expectations. Like, what is the regulatory framework we're in? And when you have so many uncertainties with unpatented mining claims and things, and kind of the difficulty of establishing title and all that weird case law around mining claims, I think some companies, I've certainly got a client that would they'd rather pay a royalty on lithium to have kind of a secure lease that can be bought, sold, traded, the rights specifically outlined, and so that it's not up to the local district court judge to kind of go, I'm not a mining attorney. And, so having kind of those expectations and clear-cut rules has got some benefit too.
Yeah, and I'm sure as case laws developed, some of these things may become more clear, but I think, especially on lithium, I'm sure geothermal the same, that time has not really played out enough to have, many situations that have come up, and those are happening today in the courts.
They are, yeah. And it's always those pioneers that are the first people out of the gate that have to pay the big litigation legal fees to get these cases decided. I mean, if you're getting a case through the Utah Supreme Court, by the time you do your district court trial and you go to Court of Appeals and you go to Utah Supreme Court, you're well into the six figures at that point. And I think that's all the more reason, as Matt has, and as you guys talk about all the time, is to see what's in your chain of title and kind of understand what potential there is for your land, so that you're making a good plan up front and you're not having to litigate these things down the road.
And some of the other things I thought were really interesting is that, again, with mining, the leases kind of mirror how oil and gas works, but it's not like you can really take a mining lease and an oil and gas lease and compare them apples to apples. Some of the things are, the percentages are much lower, though there are some things like transportation and marketing, processing. Those are a part of mining lease as well. Can you talk a little bit about, maybe some of the differences and what they call it versus, at the end of the day, it's the same concept?
Yeah, a mining lease would work off the concept of a net smelter return. And it has a lot of similarities to oil and gas. I mean, in oil and gas, we talk about, from the wellhead, and that it's kind of the oil and gas company's job to get it to the wellhead, right? And then if there's transportation and marketing and processing, especially with natural gas, to dehydrate it and pressurize it and things, that those are things that the lessor is going to see a deduction for on their check, right? And so it's a little bit different concept in mining, where whatever they get from the smelter is what you get your percentage off of. And again, those are kind of low single digit items. And so they are, how it shakes out exactly, whether one's more advantageous than another is a good question, but it works off the concept of net smelter return. So all of the transportation and marketing things aren't really the concern of the lessor, because they're just focused on that net smelter return. And how that, if you're negotiating a mining lease, that's the real benefit to having a mining attorney that has got experience, is because the way that you define net smelter return is really going to determine what your take is. And, I don't know, I'd be really interested to hear, I think, from your listeners too, and from your experience of how successful people are in the oil and gas realm of getting a no deductions lease. I mean, there are some people out there in Utah that have a no deductions lease, but it's pretty rare. And unless if a landowner comes to me and asks for a no deduction lease, the oil and gas company is going to want something for giving that up. Maybe it's a lower overall royalty percentage. And the question is like, do you really have enough wherewithal? Do you have enough net mineral acreage? Do you have enough surface control? Things like that you can leverage your interests into getting some of these no deduction leases.
And I think you hit the nail on the head. My experience, and limited as it is, has been that they'll typically ask for or grant a lower royalty in exchange for that cost-free language. So it's a trade-off for sure. And I suppose you'd have to maybe look at or have some data to understand what are the potential post-production deductions and how much could that eat into your royalty as to whether it makes sense to really push for that or go for the higher royalty and hope that they, don't eat away at that with the post-production deductions on the gas at least. So
you don't want to be a conspiracy theorist, but a lot of these companies are so integrated now that they're doing a lot of their own work and it's not third-party billing. And so are these arm's length transactions? What are other companies charging? And, how much time do you want to spend digging through your statements and comparing statements with neighbors? But, there are some companies in the basin that charge more for transportation marketing and produced water than other companies. And, I probably don't want to call them out on a podcast, but clients with those with a large area, and this is why it benefits to have someone with experience helping you out and to listen to the Mineral Rights podcast, right? Is to kind of know, maybe this operator is really sticking it to people on the transportation marketing, and it would be better for me to take a 3/16 over 20% and have a no deductions. And, from what I hear from colleagues, no deductions leases are becoming more common in Texas, Oklahoma, some areas where there's more competition. Utah is a little tough because the different companies have kind of got different areas of the basin that they work in. And so it's not as integrated. It's not maybe as competitive. But then, there's a benefit too to knowing how those operators charge and what they're charging for, and then how to best approach a lease negotiation.
Yeah, that's a really important tip, I think, to take away is that, to your point, understanding who the operator is, what their practices are, and talking to your neighbors, seeing, if they could share, sort of generally speaking, the percentage deductions they're seeing from their checks, or if you have some producing wells under that same operator in a different area, just understanding, okay, we've seen them, they're kind of the bad actor, to your point. They really have eaten into our gas royalties. And, I've seen in particular, primarily in Oklahoma, where I've experienced this, where I've seen negative royalties on the gas, that's offset, of course, by the NGLs and the oil. But, that definitely is eating into the overall royalty, and having that cost-free provision in there is something that, is worth fighting for. And I think to your point, people are more aware of it as well. So they're, I see more and more clients and listeners that I'm interacting with that are, have some of that language, whereas in the past it was a very rare thing that you would see that. It was just sort of the mineral owner would take whatever was offered, and you'd see, generally lower royalties, or if they were a savvy mineral owner, they would have negotiated a royalty higher than an eighth or higher than 15% or whatever the going rate was at that time. They would try to go for it. And it really is such a case by case, basis that you have to take a look at these things, because a lot of people just sign the lease on the dotted line when they get the first copy, not knowing that they have room to negotiate.
Yeah. And, I've been knocking AI because I'm still having to write things the old fashioned way out of my own brain. And I keep asking AI legal questions about mining and oil and gas, and it invariably gets them wrong. But one spot that people could really take advantage of AI is it's very good at numbers. And so I had a client using the paid version of Claude or ChatGPT, one of these things, and they uploaded a bunch of statements they'd gotten from other companies and said, help me break this down and understand how much I'm getting charged for different things and how that compares. And I'll be damned, AI spit out a very decent analysis, and I'm not an accountant, not really a numbers guy other than title opinions. So, there are some benefits to getting a lot of statements, and you go, well, maybe I don't know how to read these things and process them. Well, AI does, and they can break a lot of those numbers down for you and kind of make it understandable.
The question I wish I would have asked in Rocky Mountain when you did the presentation there was, in mining and geothermal and other leases, is it common to have leasehold interest? In oil and gas, you have overriding royalties that are carved out of the operator side of things. Is that something that is already happening in those other worlds? Because it just makes things even more complicated.
Yeah, they've got their own concepts for sure. The bane of a title attorney's existence is trying to calculate the decimal interest for, lessor royalty owners, for overriding royalty owners, for non-participating interest holders, for joint interest billing owners, non-ops, and things like that. And there certainly are a lot of carve-outs that happen in a mineral lease as well. I think it makes it a little simpler because you're getting the net smelter return, whereas, and this probably more comes into play not so much for a royalty owner, but I have noticed a lot of landowners, this could be a whole separate concept, but there are landowners, it's becoming more and more common to participate in the drilling, where you sign a joint operating agreement and you sign a COPUS form and things like that. And you just start thinking about, or maybe you want to, there is a company right now that's allowing kind of investment, and really understanding what the lease burdens are, for the interest that you have and kind of how that math works out. So I think in oil and gas, that's more common and more of a concern than it is in mining, because mining, you're just kind of worried about that net smelter return and not so much how the leasehold is impacted by prior reserved overriding royalties and things like that. That's probably clear as mud, right? I mean, that's probably way too deep in the weeds for 99% of situations out there. Something to think about.
Well, so what are some of the things, and I think from a royalty owner's perspective, a mining lease coming your way, the first thing I'd be thinking is, what kind of expert do I need to go to? Because maybe you've dealt with oil and gas, you need an oil and gas attorney. Let's say that you're interested in, I guess two aspects. Let's say you're approached, what kind of attorney are you looking for if you're talking hard minerals versus oil and gas? And then on the other question, we get people who are interested in really going out and finding a company that might want to mine whatever they have on their land. And I think those are both questions that we've heard about and come up.
Well, you think about pozzolan, where maybe, and I had this come up specifically with gypsum, actually, is I had a client say, hey, I've got really high grade gypsum. There's a medical use for this high grade of gypsum on my property. And can we find tell me how to mine this. Tell me how to get this gypsum thing going. And, the parcel that they were on really didn't have enough gypsum, I think, to justify some big commercial project, because it's a quantity game. And so what we did is we went out and we did research around the area and found out who the other owners were. And we started going out, part of it was BLM, and getting gypsum leases. And so that then you go, hey, we've sampled gypsum across this big area. We've got a really good high concentration here. Could be used maybe for medical. We've got some stuff over here that could be used for agricultural, but it justifies buying the equipment and getting things going. And then you go talk to the gypsum operators and go, we've secured, rights to this. And we feel good about our position here, and let's work a deal for gypsum. So you've got to think a little bit, I think, bigger picture. If you've got something on your property, to kind of understanding how far that could go. And there are consulting geologists out there that can help you figure out what the grade and what the uses of those things are, and kind of mapping the reserves. When a Canadian junior company wants to get a funding through the stock market, they're doing a lot of reserves analysis, and there are a lot of geologists that can do reserve analysis and kind of figure out where to go to kind of maximize that value. As far as getting help on the legal end, I'm afraid it's a little tough, because there are not a lot of mining attorneys around, and the mining attorneys are mostly at big firms, and the big firms represent Rio Tinto. And so there's a lot of conflict there. So I guess you have to talk to me. I'm the only one. No, I'm just kidding. I'm not the only one. But there are smaller boutique mining firm shops, especially in Nevada, that would be very competent in other states to kind of help you figure out what's going on. But it is a little difficult with the conflicts to get good mining advice. And especially if you don't have a case that, big firms, they've got a lot of overhead and they need to charge a good fee to keep everything running over there. And so they might not take on a smaller case. So,
and I would assume this is very state specific we've talked about that. So really you need to find, a mining attorney in the state where these minerals are located.
Yeah. And, if you can't, Nevada's always a good option, because there are some boutique firms there, but, I don't know if there are really mining attorneys in Idaho, for example, or I know that there are some smaller shops in Colorado as well, but it might be a little bit difficult.
I think that's a good place to maybe start to wrap it up. I think, you've really covered some interesting aspects around minerals that we haven't really talked about before, and I really appreciate your experience and sharing that with us around the mining claims and those types of things. So I'm going to definitely take a different eye when I'm out in the backcountry and I see, come across a sign strapped to a tree that talks about a mining claim being there, and somebody that staked a claim. And now I have a little bit more understanding of how they went about doing that and some of the nuances there. So that's super helpful. Anything else that you'd like to share with us from a mineral owner perspective? What are the things that mineral owners should be doing to, get a better understanding of what they own, or to help them, just kind of manage their interests from, again, some of these things that we talked about? What are the things that they should be thinking about, if that checklist of, here's the things you should know or be doing?
Yeah, I mean, not to be like a historian or anything, but we've always had this concept of a frontier and the West, and the drive for new opportunities and expansion. And I do think that the spirit of the West is alive still, especially out in Utah, where we've got geothermal popping up and lithium brine and some cobalt potential, all these different things that we really weren't thinking about before. And there still are opportunities. And I think it just pays to be curious. I mean, there's a big world out there apart from doom scrolling. I keep trying to tell my teenagers that. And, to be curious about the world and to put in the work. Life is for those who love the work is a popular saying. And I think it does pay off to be curious about the world and be curious about your chain of title and how these things work. And, the great thing is that there are so many more resources now than when I started practicing law in 2007. And we really just had the Rocky Mountain Mineral Law Foundation books, these big binders to tell us what was going on. But, we've got the Mineral Rights Podcast now, and we've got a world of information at our fingertips. And the state agencies have really become very professional. I mean, you look at a Board of Oil, Gas, and Mining hearing in Utah these days. I mean, it's run professionally. It's well staffed. You look at the materials at the bookstore. I don't know if people know, in Salt Lake, for example, at the Division of Natural Resources, they have a bookstore with endless information from the Utah Geological Service and all kinds of great books about where different mineral activity is occurring and how it's processed and developed. So it pays to be curious and look into your chain of title, look into the mineral potential of your land, explore things online, and listen to the podcast and get a better idea of the place where you're living. Absolutely. Well, no, I appreciate that. And what's the best way for listeners to get a hold of you if they have a question after they listen to this episode, or if they need help? Yeah, it's pretty easy because my office line just comes to my cell phone. I refuse to work at a big firm. Not that they would probably have me at this point, but I've gotten a little bit feral and I'm busy. So you may need to tag me once or twice, but calls come to my cell phone. I do have 2 paralegals that help me out too. So we get things done. But yeah, people are welcome to reach out for questions. I typically don't charge for, initial conversations and just spitballing. I enjoy getting to know people. I enjoy seeing what's out there. So I'm happy to talk about these kinds of things. But, if I have to write a mean letter or put a tie on, that's when the calculator comes out. So sounds good. And what's the address to your website, or where can they go to find out? Rammell-law.com. And, if you just Google Justin Rammell, it comes up. There are not too many guys named Justin Rammell out there. So perfect. And that's Rammell, right? Yeah. I appreciate that shout out, Matt. Yeah, absolutely. So yeah, we'll link to your website in the show notes. So if anybody needs help, we'll have that there for them as well. And so thanks again for your time. It's been very interesting learning about nuances of mining and, all the things around mining claims and, aspects, that we haven't really covered, and some new concepts around leasing and, oil and gas. So that's super helpful as well. So thanks again for your time. Absolutely. I refer people to your podcast all the time, and I've listened to it before, and I appreciate the invitation. It's been fun. Thanks, Justin. We greatly appreciate your time and wonderful information. Thanks again for listening.
Thanks so much for listening to the Mineral Rights Podcast with your host, Matt Sands. Don't forget to subscribe and share at mineralrightspodcast.com. The Mineral Rights Podcast should not be construed as investment, legal, or tax advice. All information is believed to be from reliable sources. However, we make no representation as to its completeness or accuracy.